I'd like to recognize our next witness, Ms. Sherrilyn Ifill. Ms. Ifill is the President and Director Counsel of the NAACP Legal Defense and Education Fund, a position she's held since 2013. In that role, she's led the LDF and increased its visibility and engagement, litigating cutting edge and urgent civil rights issues and elevating the organization's decades-long leadership fighting voter suppression.
Good morning, Chairman Cohen, Vice Chairman Ross, Ranking Member Johnson, and members of the subcommittee. My name is Sherrilyn Ifill, and I'm the President and Director Counsel of the NAACP Legal Defense and Educational Fund, or LDF. I have had the honor of appearing before this committee in the past to talk about the need for voting legislation to protect the rights of all Americans, especially for racial minorities. But I have never felt the sense of urgency or alarm that I feel appearing before you today. Last night, the US Senate failed to find the will to push past an arcane rule with racist roots. This increases my alarm, but also my resolve. This country is in a state of democratic crisis. At this very moment, states are drafting, passing, and implementing laws designed to create insurmountable barriers to voting. Those barriers are targeted principally at Black and Latino voters, Native American voters, disabled voters, and students. They include laws designed to restrict early voting, absentee voting, and the use of ballot drop boxes. They add the insult of making it a crime to provide water or refreshments to the injury of those who have to wait up to 9 hours to exercise the right that the Supreme Court has said is preservative of all rights, the right to vote. Laws have passed or are being considered that would leave Black and Latino voters vulnerable to the kind of intimidation reminiscent of the worst days of the civil rights struggle and that we saw on the rise in the 2020 election. Just this week, the governor of Florida announced a plan to create an election police force answerable to him. Even more alarmingly, states have passed laws that give partisan legislators control over the outcome of elections, no matter the votes cast. Election officials, from secretaries of state to vote counters, have experienced a sharp rise in threats to their lives and to their families. Scores of expert nonpartisan election officials have resigned from office rather than continue exposing their families to danger. This will be catastrophic for elections. Since last spring, LDF has sued Florida, Georgia, and Texas to reverse voter suppression laws targeted at our communities. These lawsuits have survived multiple attempts to prevent our clients from seeing their day in court, showing the seriousness of our claims. And we are suing Alabama and South Carolina for drawing congressional districts or state legislative maps that undercut Black voters' chance to elect candidates who will speak to their urgent concerns in the halls of power. Alabama's congressional map is akin to one person, half a vote for that state's long-suffering Black community. But we cannot litigate our way past this threat. Others, like Black Voters Matter, the NAACP, the League of Women Voters, are organizing, mobilizing, and registering voters on the ground. But we cannot organize our way past this threat. In the past, it was Congress, through the Voting Rights Act, that ensured we had strong tools. Then the Supreme Court weakened those tools, first in the Shelby County versus Holder case, and then just this past summer in the Brnovich case. And this is why Congress must act. Do not be fooled by those who call voting legislation a federal takeover of state elections. That's what Southern segregationists said about mandatory school desegregation as part of massive resistance. Tell them that their problem is not with the Congress or with the Democrats, but with the Constitution itself. Tell them that Article 1, Section 4 of the Constitution gives Congress the power to make laws that control the time, place, and manner of federal elections. Tell them that Section 5 of the 14th Amendment and Section 2 of the 15th Amendment expressly empower Congress to enforce the guarantees of equality in voting. You have the authority and the responsibility. And that constitutional power must outweigh allegiance to any congressional rule, particularly a rule that has been most often used to thwart civil rights. There's no more time to wait. Early voting for the Texas primary starts in just 25 days, and Black and brown voters will be heading to the polls with a shredded shield, facing new restrictive laws without desperately needed federal protections. Added to this, we're more than halfway through the first redistricting process in 6 decades without the full protections of the Voting Rights Act. States like Texas and Alabama have seen population growth driven almost entirely by people of color, but have already drawn maps that fail to increase representation for those people or even set it back. And not just at the congressional level, but judicial districting, school board districting, and county commissions. One expert's blunt assessment of this redistricting cycle: people of color are getting shellacked. Black and brown Americans face the greatest assault on our voting rights in decades. And only Congress can help now by passing the Freedom to Vote John R. Lewis Voting Rights Act. As civil rights groups, we will not stop pushing for passage of the legislation. Historians seeking to explain the next century of American life will look back at this very moment and ask the question: did we act when we had the chance, or did we squander our last best hope to protect the freedom to vote and save our democracy? Thank you, Mr. Chairman, for the opportunity to be here. As a matter of fact, I think this is a really important point, because one of the things it's critical to understand about the voter suppression laws that we're seeing is that the rise in these laws began immediately after the Supreme Court's decision in the Shelby County versus Holder case in 2013. Within months, Texas had decided to resuscitate a voter ID law that they would not have been able to pre-clear, that they had in fact tried to pre-clear earlier and were prevented from doing so. We sued and challenged that law, and we were ultimately successful. The trial court, in fact, found that there was intentional discrimination in the creation of that voter ID law. So the progress that Mr. Mobile talked about in Mississippi, for example, was directly the progress that came as a result of the Voting Rights Act, pre-clearance provisions, of Section 2 of the other provisions that protected against conspiracies to interfere with the right to vote. In the Reconstruction period, the Reconstruction Congress was very clear about what would be needed to ensure that Black people would be full citizens. The 13th, 14th, and 15th Amendments obviously are the amendments that were designed to ensure that. The 13th ending slavery, the 14th providing for birthright citizenship for both free and formerly enslaved Black people. Their citizenship had been taken away by the Dred Scott decision, and including several provisions within the 14th Amendment that would punish Southern states that did not allow at that time Black men to vote. And then the 15th Amendment protecting against racial discrimination in voting. In both the 14th and the 15th Amendment, the Reconstruction Congress included enforcement clauses. And those clauses gave Congress the power to enforce the guarantees that were articulated in the two amendments. That is the power from which Congress was able to pass the Voting Rights Act. It's a statute that implements the power that was given to the Congress in the Constitution in the 14th and 15th Amendments. And it was that power that Congress did not use, frankly, for the first half of the 20th century and the last 20, 30 years of the 19th century. They failed to use that power, which is why Black voters were disenfranchised in this country, particularly in the South, for most of the 20th century, until the Civil Rights Movement pushed Congress, forced Congress to wake up, forced Congress to do its duty, forced Congress to fulfill its obligations under the 14th and 15th Amendments by passing the Voting Rights Act, which provided those provisions that resulted in the ability of many Black people to be able to vote. But what was interesting, and I just add one thing about the Voting Rights Act, was that in the act, in the legislative history, what the Congress said is that the Voting Rights Act, particularly Section 5, was meant not only to address voting discrimination that they were seeing at the moment, but to address what they described as ingenious methods that might be used in the future. They didn't have laws then that kept you from providing water to people online to vote, but they knew that there would be ingenious methods in the future. That was the purpose of preclearance, and that's why we need it back. I feel I must respond to Congressman Johnson about the supposed frivolity of lawsuits challenging the Georgia voter suppression law. LDF is challenging the voter suppression law. We're also challenging the voter suppression law in Florida. And in both cases, the judge in Georgia, a Trump appointee, has denied the state's motion to dismiss, which tells you that these are not frivolous claims. These are not press releases. These are legitimate cases that will go forward and the courts will decide the strength of those claims. Congressman Raskin, absolutely, and certainly many of the provisions that we think about, automatic voter registration, absentee voting, when we talk about drop boxes outside the Board of Elections, the people they most benefit are those who are disabled. and the elderly. We should be expanding the vote for everyone. Texas's voter ID law that we successfully challenged, our client in that case was a student at a Texas State University who could no longer use her student ID to vote, but of course could if she had a concealed gun carry permit. But that also doesn't mean that we deny the targeting of Black and brown voters that has happened in the country since we received the right to vote after the 13th, 14th, and 15th Amendment. The Voting Rights Act was designed to address that for a reason. And we can't deny that history simply by pointing to the fact that there has been widespread oppression across the board of many people without wealth. Thank you so much, Congresswoman Bush. This is the place where voting discrimination intertwines with the longstanding discrimination in our criminal justice system that results in Black and Latino Americans being disproportionately represented in prisons around the country. Prisons are often located in rural, majority white areas. They very often are places where employment opportunities exist for correctional officers, particularly for white correctional officers. And when those who are incarcerated, disproportionately Black and brown, are counted as part of those rural districts where they are not residents, then that means that all of the collateral consequences of counting them there flow as well. And that includes funding, plans around development and business and jobs and so on and so forth. When in fact, they should be counted in their home communities because most people who are in prison will go home. We know that when we count in the census and we do our districting, it lasts for 10 years, but most people will be home before then. And it essentially means that resources that should be allocated to communities of color in places like where I'm sitting right now, Baltimore City, are instead allocated to places that are rural and that are majority white. Thank you very much, Congresswoman Jackson Lee. Section 5 and Section 2 were meant to complement each other, but the preferred way of addressing voting discrimination was Section 5, which is to have a mechanism to catch voting discrimination before it's implemented and to avoid the long periods of time and the high cost of litigation